there is an express power in Article 1, Section 8. It says the federal government has the power to tax in order to provide for the general welfare. Now, what's the scope of this power? What's it really mean? It was tested back in 1937 in a case called Helvering v. Davis, and that involved whether or not the Social Security system was authorized by the Constitution. Now, you have to think like a judge. The issue wasn't whether Social Security is a good idea or whether it's actuarially sound, whether guys like me like to get their check every month. That's not the issue. The issue for a judge is where in the Constitution do we find authorization for the Social Security system? And if you ask the proponents of Social Security, they said it was the power to tax, to impose a Social Security tax in order to provide for the general welfare. And back in the beginning, this was a battle. The interpretation of the General Welfare Clause was a battle between Madison and Hamilton. Hamilton's view was that the tax, in order to provide for the general welfare, was an extra added power of Congress, over and above all the other powers that were enumerated, mostly in Article 1, Section 8. In addition, said Hamilton, the government had the power to tax in order to provide for the general welfare. Madison disagreed. He said that can't be the case, because just about everything can be characterized as providing for the general welfare. And of course, in retrospect, we know that that's true. Just about everything has been characterized in that fashion. So Madison went even further. He said, not only isn't the General Welfare Clause an extra added power of Congress, but it's actually an impediment on Congress's exercise of its other powers. What it really means, says Madison, is that in exercising the other powers that are listed in the Constitution, Congress has to jump through another hoop. It can only exercise that limited list of powers in a manner that protects and promotes the general welfare and not the welfare of what Madison called factions and what we today call the special interests. The Supreme Court took a look at this and basically said Hamilton wins, Madison loses. And that opened up the floodgates through which the redistributive state was ready to pour, taking money from some people, giving it to other people without any constitutional constraints. And of course, we saw this carried out in the Obamacare decision, where Chief Justice Roberts decided that Obamacare was constitutionally authorized, not as a regulation of interstate commerce, not as an exercise of the necessary and proper clause, but as an exercise of the taxing power, the assessment of a tax in order to provide for the general welfare. And he said this even though the statute said it was a penalty, not a tax. The original version of the legislation had included the word tax, and it was stripped from the legislation, replaced with the word penalty. Elsewhere in the legislation, the words tax is used, so Congress certainly knew how to say tax when it meant tax, and it knew how to say penalty when it meant penalty. And if you look at the portion of the legislation that says where in the Constitution is this legislation authorized, there is no mention whatsoever of the taxing power. It says it's authorized by the Commerce Clause. And of course, President Obama had assured us ad nauseum that there were to be no new taxes on the middle class. Nonetheless, with a wave of the wand, Chief Justice Roberts decided that this penalty was indeed a tax. And that was the basis on which Obamacare was deemed to be constitutional. And this was all opened up with a case back in 1937 called Helvering v. Davis, when the expansive power to tax in order to provide for the general welfare was first determined by the Supreme Court. Now, I mentioned to you that the real basis for Obamacare was supposed to have been the Commerce Clause, the right and power of the Congress to regulate interstate commerce. And the seeds of our problem with the Commerce Clause go back to 1942 in a case that you've probably all heard of. It's a case, an infamous case, called Wickard v. Filburn. And the issue in that case was whether Congress's power to regulate interstate commerce could be extended to things that are not interstate and not commerce. Of course, the answer seems to be self-evident, but it wasn't self-evident for the Supreme Court. Mr. Filburn grew wheat on his own farm. He didn't buy it, he grew it, he didn't sell it, he ate it, or he gave it to his farm animals. And the Roosevelt administration during the Depression decided the price of farm products was too low, and the way you increase price is to cut production, so he told Filburn, you got to stop producing so much. And Filburn said, under what authority is the federal government telling me I can't produce so much? And the Roosevelt administration responded, we're regulating interstate commerce. Filburn predictably replies, well, guess what? There's no interstate. It's all on my farm within one state. I'm not buying it. I'm growing it. I'm not selling it. I'm eating it. The Supreme Court told Filburn he just didn't get it, that if he wasn't out there growing this stuff, he would have had to buy it. And if he wasn't eating everything he grew, he would have had some left over to sell. And so by growing and eating instead of buying and selling, Filburn and all the other folks who were probably doing the same thing he was doing, undoubtedly in the aggregate, had a substantial effect on commerce, some of which would have become interstate commerce. So that doctrine, extending the Commerce Clause from regulating interstate commerce to regulating just about anything, opened up another set of floodgates. This is the regulatory state regulating anything and everything under the rubric of the Commerce Clause. And again, it had its implications with respect to the Obamacare decision. In this case, bear in mind the Obamacare decision, even though it authorized Obamacare, was a very positive decision with respect to a couple of other provisions. So it was a glass half empty and half full. The empty part was the affirmation of Obamacare and the bastardized approval of Obamacare under the taxing power. But the court did have some very powerful things to say about the power to regulate interstate commerce. So here's the way the court looked at the power to regulate interstate commerce. And this will give you an idea of what the current framework is with respect to interstate commerce. The power to regulate interstate commerce on its face covers things that are interstate and things that are commerce. So what do we mean by commerce? We mean buying and selling goods. That's what commerce is all about. Well, what about things that are not strictly buying and selling goods and not strictly interstate, but, as in Wickard v. Filburn, they are economic acts that in the aggregate probably has a substantial effect on interstate commerce? Well, what's an economic act? It's far broader than just buying and selling. An economic act could be, for example, growing, as in Wickard v. Filburn, consuming, as in Wickard v. Filburn, manufacturing, mining, distributing, and of course, buying and selling. So the economic acts is a superset of commerce. Economic acts are far broader than commerce. And after Wickard v. Filburn, the new rubric was not only can Congress regulate interstate commerce, but also even intrastate acts, as long as they're economic acts, as long as they're growing, mining, manufacturing, distributing, buying, selling, or consuming, economic acts that in the aggregate, even though they're intrastate, have a substantial effect on interstate commerce. So that was the rule for 50 years. And then along came another case called United States versus Lopez, which oddly enough involved guns. And the issue in the Lopez case was whether or not federal government could pass a law that says it's illegal to possess a gun within 1,000 feet of a school. And the Supreme Court took a look at that and finally drew a line and said, no, this is too far. This is not commerce. This is not an economic act that affects commerce. The mere possession of a gun is a non-economic act. It doesn't involve growing, mining, manufacturing, distributing, buying, selling, consuming. It doesn't involve anything. It's just mere possession. And so the new rubric after United States versus Lopez was Congress can regulate interstate commerce. It can regulate economic acts that have a substantial effect on interstate commerce, even though they're intrastate, but it cannot regulate non-economic acts, like the mere possession of a gun. And that's where things stood up until Obamacare. And Obamacare went a step further. Obamacare proposed a congressional power, federal power, to regulate, under the Commerce Clause, things that were not acts at all. Because what we're talking about is a penalty for not buying insurance. So if consumers decide not to engage in an act, the federal government claims the authority to regulate them under the Commerce Clause. And the Supreme Court, Chief Justice Roberts and the other four conservative justices, to their great credit, drew another line in the sand. And they said, Congress may not mandate an economic act in order to be then able to regulate that act under the rubric of the Commerce Clause. That is regulatory bootstrapping of the worst sort.